Sri Lanka's judicial sector recently introduced temporary provisions to make certain legal processes easier to implement amid restrictions posed by the ongoing COVID-19 pandemic. The Coronavirus Disease COVID-19 Temporary Provisions Act No. 17 of 2021 proposes three key changes. Firstly, in relation to situations where people or parties are unable to perform certain actions required by law within prescribed time periods.
So essentially, the law, when it comes to court cases, has certain mandatory periods that you have to do things by. What happened is, due to COVID, there were lockdowns and courts were closed at certain points, registries were closed, people were unable to sort of leave their homes or do anything. So there have been obviously so many instances there were, and there obviously should be, where people are not able to carry out these prescribed or sort of carry out these mandatory steps on time within the time periods given by the law. If due to those reasons you are unable to perform a task, then the COVID-19 Act gives the court the ability to give you relief.
The second provision aims to assign alternative courts in any case where a court cannot function due to COVID-19 circumstances, and to conduct court proceedings via remote communication technology.
COVID doesn't sometimes stop all the courts operating. Sometimes there are breakdowns or breakouts in specific areas, whereas one court can't function, and when a court doesn't function for a few days or a period of time, there's a backlog, and that delays the whole process quite a bit. Prior to the act, there was nothing that could be done. It was only that court that could hear that case, and that was it. But the COVID-19 Act does is it allows for the designation of all alternative courts.
The designation of alternative courts in this case include hearing the case in the court nearest to the disrupted court within the same jurisdiction, or virtually via remote communication technology such as Zoom. The third provision in the Act aims to grant relief to parties who are unable to perform contractual obligations due to COVID-19 circumstances.
You can still go to court and establish that your inability to perform certain tasks was due to COVID, and the court can take that into account. The law is not sort of meant to allow you to disregard contractual obligations completely. It's not what it's supposed to sort of change the balance of a contract between the parties, but it's sort of with the aim of balancing out how unfairly a party would be affected and giving them the requisite sort of ability or the option to perform their obligations under the contract time-wise.
The provisions included in the Act are in line with the Ministry of Justice's wider reform program, which includes the digitization of legal processes and addressing delays in the legal system. The COVID-19 Temporary Provisions Act came into effect on the 23rd of August.